Oye. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable.
Good morning. We would ask if your case is not up on the first case, ask that you would disengage your video. All right. Thank you so much. Hey, Mr. Palatera, you're in the fourth case. Mr. Palatera, can you hear me? Mike, is he not? Okay, good. Thank you. All right, Mr. Klein, you may proceed.
May it please the court. My name is Stephen Klein on behalf of Dennis Fusaro. As the clock reflects, I've reserved 5 minutes for rebuttal. Dennis Fusaro is a political consultant with broad experience that ranges from election campaigns to grassroots advocacy. His speech in this case stems from the latter. His desire to speak out about the Maryland State Prosecutor, a past campaign finance prosecution against him by the state prosecutor, and even this pending case. He would do so via direct mail with names and addresses drawn from the Maryland Registered Voter List, which is furnished by the State Board of Elections. But Mr. Fusaro cannot do so without risk of another prosecution by the state prosecutor. That is the risk of criminal charges and imprisonment under Maryland Code Election Law Article Section 3-506 for using the list for a purpose, quote, not related to the electoral process, unquote. These electoral process restrictions are unconstitutional under the First Amendment for at least 2 reasons. They fail Anderson-Burdick balancing, and they are unconstitutionally vague. Beginning with Anderson-Burdick balancing as to this content restriction, the only remaining state interests are protecting privacy and, more relatedly, encouraging voter registration. The burdens on Fusaro are substantial, a deprivation of a valuable political tool for engaging Maryland voters through a tried and true medium, direct mail, which Mr. Fusaro in his deposition discussed his experience and the effectiveness of, and it's available in the joint appendix beginning at page 312. This serves as a powerful deterrent to the open discourse of ideas that is the hallmark of a free people. The state interests are really just kind of speech restrictions dressed up. They're over-inclusive because they sweep far too broadly. Bears noting, despite what some mentions in the opponent's briefing, that name, address, and voting history are the only things provided on this list. Date of birth, phone number, email, these are not provided. There's no interest in preventing robocalls here. The list itself is now available under the National Voter Registration Act. That's why the electoral process restrictions are now part and parcel and just front and center in this case. How can it be private if anyone can get it now? Maryland registered voters, Marylanders who are not registered to vote, nonprofits such as Judicial Watch, and even Mr. Fusaro himself, who has in fact acquired a copy of the list. The state interests are also under-inclusive. They provide distinctions really without a difference when it comes to the content that is being censored. Never really discussed is how are election mailers? It permits election mailers. We see this in one of their footnotes in their brief acknowledging that one could in fact send a letter that is relating to a political campaign or expressly advocating for the election or defeat of a candidate perhaps while discussing a big issue, or maybe even, the electoral mudslinging we see every election cycle. That is
Mr. Klein, is your challenge facial or as applied?
Both, Your Honor. But as applied, I think it certainly shows, particularly
if it's as applied, isn't it moot now?
Your Honor, the access provision is moot in section 3-506. It is not moot as to Mr. Fusaro's mailers. Particularly, I think the argument there from opposing counsel is that his vagueness argument has been waived in some fashion. But as far as these content restrictions, there seems to be at least some acknowledgement, though the opposing counsel and opposing parties did everything they could to not say, not give an opinion as to whether Mr. Fusaro's mailers are related to the electoral process or not. Again, accepting that they are not, the idea is what difference, what privacy is being protected when mudslinging emails or mudslinging mailers can be sent out by candidates, but Mr. Fusaro cannot send his letters. That's where this balancing, again, should tip in favor of Mr. Fusaro being able to engage in broader political advocacy. Where it gets very strange, and I think that I will emphasize here for the first time and will continue to do so, is
Mr. Klein, are you suggesting or arguing that the state cannot restrict these letters to political or electoral process? Let's assume that could be defined or is defined appropriately. Are you saying that the state could not limit the use or letters or restrict the letters sent out to electoral process?
Yes, Your Honor. I don't believe it's appropriate here because of the speech interest for Mr. Fusaro, and moreover, pages 48 and 49 of the appellee's brief.
Well, the answer to the question is yes. You would say they're limited. To do from that to that, limited. They can't do that.
Oh, yes, Your Honor. I would argue they cannot. Mr. Fusaro cannot send his letters.
No, it didn't say he couldn't send the letters. It says that the restriction is, you can't be involved. You can't do it in being involved in anything limited to electoral process. You're saying they can't do that. See, your vagueness part, I'm assuming it's not vague. It's not overbroad. I'm just saying, are you saying that's an appropriate restriction?
It is not an appropriate restriction, Your Honor.
How do you then square that with Lehman? I know Lehman was a little different. It was on a bus. It was a transit thing, but why couldn't they restricted everybody from doing that? It was well-defined and no one could use it for anything other than the electoral process. Why couldn't they do that?
I think the biggest problem, Your Honor, is that some people can, and that's where the pages 48 and 49 of the appellee's brief basically provides a very big and interesting problem that incumbents may use the letter to send anything they want relating to, and I quote, unofficial legislative newsletters to disseminate information to a constituent, voter, or potential voter about one or more issues of public interest chosen by the incumbent. So we discussed that actually, as far as, again, privacy, this restriction only applies to certain people, right? We're not actually protecting, using that term loosely, or preventing strictly things that go to the electoral process. And I understand, and the courts beg the court's indulgence as far as a lot of these issues kind of ping-ponging back and forth between one another. But as far as this burden of a powerful electoral tool being prohibited in this fashion should weigh, in fact, in favor of Fusaro, not in fact in favor of the state.
Are you still claiming there should be strict scrutiny?
Judge King, yes, I am. And that's where things get very interesting as far as the mootness of the access provision in this case. Exercising constitutional avoidance, the court below decided that the access provision, because anyone can get the list now under the NVRA, that it's moot and we're just going to analyze the electoral process restriction. But it's not so much constitutional avoidance as a constitutional collision with Sorrell versus IMS Health. This, understanding again, the procedure of this case is a little messy, but if all that's left now is a content restriction on information that is required under federal law to be disclosed to people, it parallels Sorrell versus IMS Health almost perfectly. But instead of dealing with speech about pharmaceuticals, we're dealing with political speech, the core of democracy. The case echoes in so many ways that I would argue, at least in the third. Now, sticking with the law of this case, with this court's prior ruling, Anderson verdict and vagueness, either of these are independent grounds to strike these provisions, but it is so the law of the case should not control, perhaps instead the law of the law as it stands now, because Judicial Watch versus Lamone was not appealed. Anybody can get this list now. So this content restriction under state law is really more akin to IMS Health and is removed from really public records doctrine. So
you said a while ago, or at least I thought I heard you say, you could not send your letters. What did you mean by that?
Your Honor, using the list for a purpose not related to the electoral process. And Mr. Fussaro's letters, I think the state, again, saying, well, he's just self-censoring. We're not going to say one way or the other whether we prosecute him for sending these things. I would say he's either chilled by vagueness from sending them, or he is directly censored because he's not really talking about the electoral process. I do, want to emphasize as well, there's some discussions of standing and a certain pigeonholing of this case to a place that vagueness doctrine can never be argued in the alternative. And I have serious concerns about that. And I certainly think that the court below had no desire to say one way or the other where Mr. Fussaro's letters would fall. And arguably, maybe they would, maybe they wouldn't. We won't really know until if he takes that risk, which is the problem under criminal law.
Well, what would be the content of the letter if it's outside the electoral process? What do you talk about sending?
Your Honor, his second, the letter is basically a critique. The joint appendix, at least the most recent letter that no longer criticizes the former state prosecutor. But his second letter is in the joint appendix, page 350. And it is again, a letter encouraging the state voters to contact the state prosecutor's office and perhaps take different priorities when it comes to prosecuting political speech cases. Now, again, it's interesting that
why isn't that in the electoral process? What you just said is talking about the electoral process and responsibility of elected officials.
Your Honor, getting an answer on that would be excellent. And I think that's the concern here is, again, it's such a amorphous standard. Again, pages 48, 49 of the appellee's brief, suddenly they suggest a narrowing construction, right? They suggest at one point, because there's, we have not related to the electoral process, and then we have the defendant's brief pointing to at least like 4 different definitions of what we might do with this. Most of them just rearrange and add more words that don't really add any clarity, but they suggest a narrowing construction of expressly related to the electoral process. And then immediately follow that with a discussion of, yeah, but incumbents can go ahead and send mailers that have just discuss issues of public importance that matter to them, because that's a permissible campaign expenditure under the election law. Now, that was nowhere discussed in the court below or the substantial joint appendix we built, but that's news to me. The 30B6 witness for the Maryland Board of Elections even said a legislative mailer like that would have to have a more express purpose to increase an incumbent's visibility or his electability. So we don't, it keeps moving. It's a moving and amorphous target. So yes, it is vague, and it provides, for both reasons. It's not readily understandable by a person of ordinary intelligence, and it also is arbitrary, poses the risk of arbitrary and discriminatory enforcement.
Well, if there's some question about electoral process, the definition thereof, typically what we do is go to various treatises and dictionaries, and in particular, Black's Law Dictionary, which does define the term electoral process. So by reading that definition in Black's, won't you know what you can do or not do?
Your Honor, I think relates to is the other big problem, okay? And that's where it's, especially with a so-called narrowing construction, we say, related generally.
You don't understand what relate to means?
Your Honor, Your Honor, it has been narrowed in many contexts, particularly in campaign finance law. That has been, you can't just go, okay, you can't just require campaign disclosure, for example, of things that are related to, political advocacy. And then they provided a narrowing construction that goes back to Buckley versus Vallejo. Here we're talking about bans, a speech ban, criminal penalties for violations. And there needs to be some kind of understandable definition, one that does not involve, connect the dots so that, hey, if it's a permissible campaign expenditure, it is part and parcel of the state's words of the electoral process, even though the content is not expressly related to the electoral process. So I raise, I think, again, the First Amendment standards here, regardless, under this posture of the case, there's myriad reasons for violations of the First Amendment here, and we ask that this court reverse the court below.
Thank you so much, Mr. Klein. Mr. Trento?
Thank you, Your Honor, and may it please the court. 4 years ago, nearly 4 years ago, Mr. Fusaro initiated this lawsuit, intending to communicate with Maryland residents about what he believed was his unconstitutional prosecution by the then state prosecutor of Maryland. And to do so, he wanted to use a particular government record, the list of registered voters that Maryland makes available to applicants subject to a certain condition. And that condition is relevant in this case, is that the applicant must swear that they will not use the list for commercial purposes or any other purpose not related to the electoral process. But importantly, a person who does not agree to this condition is not then foreclosed from communicating with Marylanders. Far from it. A person may use campaign donor lists, which are publicly available and free on the Maryland Campaign Finance website. A person may obtain lists from the private sector, may utilize services available through the U.S. Postal Service, may conduct a targeted social media campaign to distribute letters in that way, may leaflet, may distribute flyers, may even use the popular press. Even someone
who pays for that list, Mr. Trento? Who when somebody asks for that list from the state, who pays for that?
There are two people who pay for it, Your Honor. One of the conditions on accessing the list is to pay a fee. I think the current fee is $128 to obtain the list. But obviously, maintaining a database with voters, like the list of voters constantly updating, costs more than just the $128 fee to make the list available to people. And so to some extent, it is subsidized by the state. The state doesn't charge what the real costs of maintaining that list are. So in another sense, it's also subsidized by the state.
Well, that means the taxpayers are paying the cost.
That's correct, Your Honor.
Well, wouldn't the state have an interest in protecting the taxpayer?
That is one of the interests that the state has in this case. It certainly, there was the registered voter restriction that Mr. Klein alluded to earlier. By making the list available at the outset initially to only Maryland registered voters, the state was attempting to provide a subsidy to those taxpayers to those Maryland taxpayers who are indirectly funding the maintenance of the list in the first place. But as Mr. Klein alluded to, the Judicial Watch case ruled that the registered voter restriction, and only the registered voter restriction, was preempted by the National Voter Registration Act because it presented an obstacle to the accomplishment of Congress's objectives in passing that legislation. One of those objectives was to ensure that states maintain accurate voter rolls. And the court concluded that a limitation on who can access that list based on where they live or whether they're a registered voter was incompatible with it, was an obstacle to the accomplishment of that objective. This is not the case with the restriction at issue now before the court, which is the condition that a user agree or an applicant agree not to use the list for any purpose not related to the electoral process. In fact, Judicial Watch in obtaining that list had no issue with swearing that oath because the purpose for which they acquired the list was to ensure the accuracy of the voter list. And that is consistent with a use related to the electoral process. So that condition continues to apply here, and any non-Marylander or Marylander alike seeking to obtain the list must still abide by that condition.
Mr. Trento, you said electoral process. Do you agree that that's bigger than just running for the office?
Well, certainly it's bigger than just running for the office, because I think electoral process also encompasses the mechanics of an election. It encompasses maintaining the accuracy of the voter list. It encompasses how elections are administered in the state. And so certainly it also encompasses competitions and candidacies, and one candidate versus another, and advocating for a candidate's election or defeat, but it's not limited to that, Your Honor.
Right. So it also includes information that is about what a person or what the citizens who they're going to vote for and what issue. Would you agree that's part of the electoral process, educating?
I absolutely agree, Your Honor, if it's framed in the context of who they want to vote for. I think that there just needs to be a hook. There needs to be some sort of connection drawn between the intended use and the electoral process, whether that's a particular candidate or a competition, whether that's a general advocacy that in the next election, voters should consider those candidates and elect those candidates who believe this particular issue. I think there just needs to be a connection to an election or an electoral process. And the problem with, I'm sorry.
I'm just looking at your interest, and certainly you would say this is not a viewpoint restriction, correct?
Correct, Your Honor. It's not a viewpoint restriction. And let me...
means you can say negative things about people who are in public office in order information is to be positive or negative, correct?
That's the nature of electoral communications, Your Honor, as Mr. Klein referred to the mudslinging that all of us are familiar with and we see during elections. It's mudslinging. It may be unappetizing, but it's also related to the electoral process. And if I could, Your Honor, you referenced viewpoint neutrality. If I could address Mr. Klein's the concern he raises about legislators having an ability that average citizens like Mr. Fusaro don't. And I believe that's a misreading of the law. What section 13406 of the election law article of the Maryland Code allows legislators to do is to use campaign funds to share their legislative accomplishments or issues of concern to the incumbent with voters. But by using campaign funds, they are by definition advancing the electoral process prospects of the candidate and are required to slap an authority line on the transmission. In other words, that letter will have at the bottom of it paid for by friends of Chief Judge Gregory or paid for by friends of Dennis Fusaro under the authority of the treasurer of that campaign. There is an express connection to the electoral process in that transmission. And Mr. Fusaro is able to do the same thing. He can use the list to share with Maryland voters issues of concern to him, as long as it's in some way connected to a candidacy, connected to the electoral process, the administration of the election, the mechanics of the election, when election day should be. There are any number of ways that one can connect issues to the electoral process, but there needs to be a connection. And the problem with Mr. Fusaro's intended uses, his purposes for which he wants to communicate with Maryland voters, and the letters that he has drafted to do so, is that he admits that they are not. He goes out of his way to avoid any connection with an electoral process because, as the record reflects, for other reasons, he's afraid of being prosecuted for lacking an authority line on his transmission. And so Mr. Fusaro concedes that his letters are not related to the electoral process, and so he shouldn't be heard now to complain about not knowing where the boundaries are. So this is the situation Mr. Fusaro finds himself in. He is free to communicate his letters word for word using any of the other tools available to him, but he has chosen to, and it is a choice, to litigate this case for years to try to be able to use a voter list in order to do so. This isn't a speech ban. It's not a restriction on what kind of speech he can make. It's just a restriction on his use of a particular government record in order to engage in that speech. The district court, when this very panel heard this first appeal, it recognized that there was a First Amendment dimension to what Mr. Fusaro intended to do, and it remanded the case with instructions to the district court to weigh the burden imposed by this access restriction on Mr. Fusaro's First Amendment rights against the state interest supporting this restriction. It also instructed the district court to evaluate Mr. Fusaro's vagueness claim. The district court has done so.
All that was thoroughly done, was it not, sir?
Your Honor, I think the record is is fulsome. The issues were litigated below. Mr.
That's
Fusaro.
what I'm getting at. I want you to tell us what y'all did when it went back.
Sure. We for Mr. Fusaro amended or supplemented his complaint, given that Mr. Davitt had resigned. He drafted a new letter that was intended, again, largely similar message, but intended to include information about this case and to direct Maryland voters to contact the state prosecutor and tell the state prosecutor not to bring prosecutions in violation of the First Amendment. Then we entered a period, the complaint was answered, we entered discovery. Mr. Fusaro was deposed, the State Board of Elections witness was disposed, interrogatories were served and responded to, and then we went to summary judgment. The district court evaluated the claims on the basis of what this panel had directed it to do with the benefit of a full summary judgment record and found Mr. Fusaro's claims to be without merit, and that should be affirmed. I'd like to.
And the district, I'm sorry.
Go ahead, Judge King.
The district judge then penned a very thorough opinion on remand as well. Is that correct?
Your Honor, I believe the district court's opinion was thorough and complete. It addressed all the issues, and fundamentally it was correct. And for that reason, it should be affirmed. There's no need for this court to revisit the standard that it selected to be applied in this case in the first instance. Mr. Fusaro is trying to reframe this case now as Maryland attempting to regulate his use of information already in his possession, like in the Sorrell case, as opposed to imposing a condition of access that Mr. Fusaro has agreed to abide by. And that's simply not the case. In Sorrell, the information that was in the possession of the pharmaceutical companies was already in their possession. There were laws, the laws attempted to regulate what they could do with it, but that was information that they gained in their normal course of business. And the Supreme Court said in that case, the state cannot, absent satisfying strict scrutiny, cannot limit what those entities could do with that information.
Mr. Trento, it seems to me that, or at least there's a hint, that the appellant is trying to use the O'Brien test for symbolic speech. Is that your understanding?
Well, I think he may be. I think what he's trying to do, Your Honor, is turn this case into Sorrell. What he's trying to do is whatever this panel decided to do in the first instance, given the fact that Mr. Fusaro didn't have the voter list yet, he now has the voter list. And so the court should evaluate this case as though this were Sorrell versus IMS. And for the reasons I stated, Judge Floyd, it's simply not Sorrell versus IMS. If anything, I would say that Mr. Fusaro, by agreeing to the condition that he not use the list for a purpose not related to the electoral process, he has mooted his claim that the condition violates the First Amendment, because it's not so much the state law that's restricting him, it's his own agreement and oath that he would swear that he not do that. And so the court is not, the court should not go back on the standard that applied in this case in the first instance, because the facts are essentially the same. This was a condition of access that he's still complaining about, and that's how it should be evaluated. In the district court, the district court correctly did that evaluation and correctly concluded that the electoral process condition passes constitutional muster under Anderson-Burdick. As the court is aware, the Anderson-Burdick test requires weighing the burden imposed by the restriction on the applicant or on the plaintiff against the interests of the state that are furthered by the restriction. As this court has already concluded, the burden on Mr. Fusaro imposed by the electoral process requirement is not severe, but the record now shows how modest it really is. In his deposition, Mr. Fusaro explained that his need for the list was based on wanting to reach civic-minded Maryland residents, but he could not meaningfully articulate why the voter list would be preferable to other resources to reach such individuals. He attempted to do so by suggesting that the state prosecutor would be more responsive to letters from voters, but that's expressly contradicted in the record by the state prosecutor. That's at 410 of the joint appendix, and who in any event is not appointed by elected officials at all, but rather a commission on which only 2 out of 7 of the members are elected officials. It's not even clear how the state prosecutor would even know he was being contacted. I'm a registered voter, Mr. State Prosecutor. You really should you really should not prosecute people in violation of the First Amendment. Mr. Fusaro also acknowledged that other resources like campaign donor lists, which are publicly available on the internet and free, could also be useful for his exercise. Specifically, when asked why he couldn't do with a free publicly available contributor list what he wanted to do with the voter list in this case, Mr. Fusaro replied, "I don't know. I haven't done the full analysis yet. I might want both lists." That's at 346 to 47 of the joint appendix. Mr. Fusaro also intends to spend only several $100s sending his letter, which would allow it to reach only the smallest fraction of the 4 million registered voters in Maryland. But presented with this, Mr. Fusaro had no idea how he would identify those recipients from the 4 million strong list of registered voters in Maryland. His response to the specific question was, "Wow, I hadn't gotten that far." That's the Joint Appendix 335. Now, my recitation of the record here is not to denigrate Mr. Fusaro's views or suggest that they are not entitled to First Amendment protection, nor is it somehow to criticize his access to resources or belittle what he intends to do. But it's simply to underscore that not being able to use the voter list to send his intended communication does not impose a burden on him in any meaningful way. There are other resources that don't have this restriction that are available to him and that he can utilize for the same purpose. No law in Maryland prevents Mr. Fusaro from sending the same letters word for word to Maryland residents using any other available resource. The unavailability of the voter list for this purpose does not meaningfully burden his ability to communicate with Marylanders, even civic-minded Marylanders, about anything. Now, in contrast to these burdens, these modest burdens, Maryland's interests are important and supported by reasoned, credible argument. Promoting voter registration is well accepted and even laudable, as Mr. Fusaro says at page 8 of his reply brief. What it is not is censorship by another name. The record shows that the Board of Elections receives 15 to 30 complaints a year from voters about the availability of their public voter registration information. The legislature in Maryland has accounted for these concerns expressed by voters by imposing conditions on access that required applicants to swear they will use the list only for certain purposes. Restricting permissible uses has a credible relationship with fewer efforts to contact people whose information appears on the list and fewer voter complaints about such contact.
Yes. You talk about Mr. Fusaro has other access or means of getting this, but you lost on that issue really the first time. Your argument was, well, no, this is really not speech at all. This is just really documents. And you lost on it because we found that, no, this is closely tied to speech. So you didn't win on that, but you're relying today heavily on that argument. But we look, you're almost like non-public forum. And I don't recall we say that, oh, wait a minute, you lose because you could go someplace else. Like again, I take it back to Lehman cases. We look at those ideas that you can post things on certain non-public places and they have restrictions. It's not resolved by saying, wait a minute, why don't you go down the street and post it someplace else? That's not the analysis. But it sounds to me that you're putting a whole lot of, fruit in that basket on that saying, well, you keep saying, oh, he could do it someplace else. But you lost on that. If we had said, you're right, this is like just documents, but we didn't say that. Instead, we say, no, go back and look at this on the speech principles of vagueness. And then also in terms of the burden shifting as to interest versus burden. That sounds like speech to me. It doesn't sound like something that can be easily jettisoned by saying, oh, let them eat cake, go someplace else. What's your response to that?
Sure. Thank you, Judge Gregory. And I think it's an important distinction that you're raising. You're right. I lost before this very panel the last time we were here in trying to argue that this was just a record and he had other ways of doing it. But if you had agreed with me then, Your Honor, you're right, I would have won the case. But we are back, and what Your Honor and what this panel did when this case was here the last time is it remanded the case for the district court to weigh the interests of the state against the burden imposed on Mr. Fusaro. And an assessment of the burden imposed on Mr. Fusaro necessarily entails looking at how his speech is harmed by not having access to this list. And what the record shows is the access to the list is not particularly important for what Mr. Fusaro is trying to accomplish here, in part because there are other resources for him to utilize, but also because his particular interest in this list is just not consonant with the purpose that he intends to use it for. He just doesn't intend to utilize the list to try to reach very many voters at all. He doesn't know how he's going to select voters. He doesn't know, he wasn't able to articulate why the state prosecutor would be more responsive to letters and communications from voters who don't even identify themselves as such. It's just an explanation, Your Honor, that the particular burden on Mr. Fusaro in this case is not particularly weighty when confronted with, in juxtaposition to the state interests involved. Now, if there was a specific need that he could have articulated that this list is critical for these particular reasons and none of these other resources that are available would allow me to engage in the speech that I want to engage in, we'd have a different case. But we don't have that case before this panel right now. And so I would submit that that aspect, the availability of other resources, is a component of the burden that this court remanded for the district court to consider. And so I see my time is up, and so unless there are other questions, I'll stop my presentation.
All right, thank you, Mr. Trento. Mr. Klein, you have some time reserved.
Thank you. The point about donor lists, that Maryland does put out a different exclusive kind of list of donors, Marylanders, including their names and addresses, who give money to certain candidates or political committees, undermines one of their own asserted interests in privacy. So we throw this kind of information out there publicly, go ahead and use it for issue advocacy, but we're going to protect voting history and otherwise names and addresses on this list. Moreover, as far as encouraging voters to vote, they continued, citing, Mr. Trento just cited 15 to 30 complaints a year over its current uses. That's 0.0000075% of the 4 million plus Maryland registered voters. If these are governmental interests that support censorship, I don't know what isn't, and that's a very chilling thing under Anderson-Burdick, and that is why this should tip. Mr. Fusaro was deposed prior to the district court's ruling below, prior to its ruling in Judicial Watch. He was being deposed when he did not have access to the list at all. So the idea that he hadn't gotten that far as to how he could, use it, I think is a little bit not used properly or not cited properly here. And moreover, he did mention in his deposition that he would endeavor to fundraise to spend more money, but he is on his own of limited means. So this burden, this idea, and we have the testimony of the 30B6 witness noting that this is drawn from a central database, MD voters. It's updated every day. It is the way to get and assess on its face here, not that assessing the political engagement, at least via voting history of Marylanders. Depriving Mr. Fusaro of this list is a burden, certainly a greater burden than the two interests asserted that still remain by the government. To your point, Judge Floyd, about subsidy, I just think under the NVRA, this list is now required under federal law to be provided. I think the subsidy is really a red herring at this point. To Mr. Trento's point, I respectfully but strongly disagree with his representation of IMS versus Sorrell. That was not a case. It was a case brought by pharmaceutical companies and data miners relating to access to information that was in the hands of pharmacies. So it was, in fact, this access case. It's not me and it's not Mr. Fusaro who have transformed this case. In fact, it's the ruling of the court below. That's, again, what this is now is a state restriction, a content-based restriction. And we can agree on that. Page 47, footnote 19, again, is one of the closer things, is material discussing Black Lives Matter standing alone and without any reference to an election related to the electoral process. No. Is material discussing Black Lives Matter and its impact on an election on one or more candidacies related to the electoral process? Yes. This is not complicated. Well, it is at the very least a content-based restriction on speech, and it is now very much on the use, there's really no more access to this list problem here. This really is entirely about what this information that is in fact in private hands can be used for. Unless there are no further questions, again, I urge that the criminalization of speech is a serious problem here. There are numerous doctrines under the First Amendment that may be used to overturn the ruling of the court below.
Mr. Klein, let me ask a question. Since you have not sent in a letter, I think I'm correct about the record as it stands here. Aren't you really only left with the question of whether or not the chilling effect is so strong that it's a restriction? Because we don't know whether your letter would be passed muster or not, or whether it would be a violation or not. Aren't you left? You have to convince us that it's an incredible chilling effect on you. Wouldn't you be left to that?
Your Honor,
because as Judge Floyd asked about it, and you're still insisting this is as applied, so we don't know what the application is yet because the instrumentality is not before us. So we're left with your chilling effect, don't we? Aren't we?
Your Honor, I think it does. I think it goes both ways. And I think the chilling effect, that's the very problem of censorship. The sword of Damocles, is often brought up in these vagueness concerns. And moreover, I do want to reemphasize Mr. Fusaro's complaint. He has 2 letters, but he has also asserted, that he would use this for various purposes. And that got a little bit chopped up even in the court below as to, numerous letters that he wouldn't send because A, they're not related to the electoral process, or B, he doesn't really understand what this term means. So I do think both those issues are properly, before this court, albeit I did just add A and B there to my paragraph. But, again, I see my time has expired here. If there are no further questions, again, I urge reversal against the criminalization of speech.
All right, thank you very much. Mr. Klein, Mr. Trento, thank you so much for your argument. We wish we could come down and shake your hands in our normal Fourth Circuit custom, but we can't do that. But please know nonetheless that we very much appreciate it and your arguments. Thank you so much, and be safe and stay well. Thank you.
Your Honor.
We'll proceed to our
Thank you, Your Honor. May it please the court, I'm Mike Bragg. I represent Brian Davidson, a parent of students in the Loudoun County school system. At the time of the events that brought us before this court, he had children at the Sildon's Landing Elementary School. Brian is a professional and had become quite a community activist, raising all sorts of issues regarding the administration of the schools there, and it's particularly with regard to Selden's Landing. He raised issues under the federal, various federal statutes over a period of time that culminated in the fall of 2015 with the issuance to him of 3 letters starting on September 29th, followed up on October 8th, and then finally on October 14th from the principal of Selden's Landing, banning him from coming on the Selden's Landing property under penalty of prosecution for criminal trespass. This suit ensued, and of course, where Mr. Davidson raises issues related to his constitutional rights. This case is related to various litigation that has happened and is going on regarding the relationship of the public school systems with students, as reflected in the United States Supreme Court case of Mahaney that was decided just this year. Mr. Davidson's case as a parent. There's litigation that's actually now ongoing with Loudoun County School Board involving teachers as they're applying this no trespass policy The case has gotten quite a lot of national publicity. The case against Tanner Cross, who was a teacher who spoke during a public comment time against a proposed new policy. And because of his opposition to that policy, was suspended from his job and was given a no trespass order to stay off school property. That case is still pending, although at the Pendente Gladi injunction granted against the school system was affirmed by a written opinion by the Virginia Supreme Court just last month. That is the Commonwealth Record, Supreme Court Record 210584. Obviously, we've raised a lot of issues in this lengthy brief and a very large appendix, and within our allotted time, there'd be no way to argue all of those. What we don't mention today, we are not waiving, and we're falling back on that briefs that have been submitted. There's a few issues that we want to address today. The first I want to address is the question of the district court's granting of res judicata effect to the order entered by the Circuit Court of Loudoun County, where in a case by which Mr. Davison, after his banning and with his process with the school board, he filed a petition to review that under statutory procedure within the circuit court. He filed that pro se case, sit for a while, and after the federal 1983 case was filed in the Eastern District of Virginia, he went to that court asking to non-suit it, essentially on two grounds. One, that the issue that could be raised there, the banning of property had expired by its own terms with the end of the school year. And secondly, he wanted he had the case pending in federal court, and he was going
Mr. Judkins, let me ask you this question. How can you make an England reservation claim during state court proceedings when you agreed to dismiss the appeal at the state court with prejudice? Isn't a dismissal with prejudice a final order?
Your Honor, you're addressing that to me. You missed.
Yes.
Thank you. I think it matters not that that the order stated with prejudice. Under England giving notice to the court that you are reserving your federal claims for federal court is sufficient, and he did so explicitly, and did so in his lengthy motion to non-suit, and that is found starting in the appendix at page 697. Did probably a much more lengthy motion than pro se than most attorneys would have done. But in that lengthy motion, and at least 1, 2, 3, 4 places mentioned that he is reserving his federal claims, and that case needed to be dismissed so that he could go forward with his case in the Eastern District of Virginia.
But you could have just withdrawn just withdrawn the appeal, and he wouldn't be in this predicament, wouldn't you?
Not necessarily, Your Honor. There really, there really is no statutory or rule provision talking about withdrawing an appeal. Now, that is language that we use. I have done the same thing. The effect of withdrawing, if you withdraw that petition, withdraw that appeal, there still has to be an order to remove the case from the docket, which would essentially be a final order. And unless it's stated without prejudice, it would still be a final order with prejudice. So with withdrawing the appeal is not it's not something that would have made the our circumstance, I think, any different. But ultimately, what we say is that under England and England's progeny, if the person having a federal constitutional claim tells the state court that they are intending to litigate those federal issues in federal court, that ends it. I would say even if the state court said, no, you're not, you're in front of me and I want to rule on it over your objection, then yeah, you still would have reserved it under England. The principle and the
reserved it for both the federal court, the state courts, you're saying?
I'm sorry, Your Honor.
What?
Your Honor, would you repeat your question?
I said it's reserved for what court? What do you
Reserved for the federal court. If you tell,
so you can go to state court to reserve the federal claim for the so that you can get the state court to decide what the federal court can do.
no. What I'm saying is that if a person has a case pending in state court, and whether explicitly the federal issue was raised or it's merely implicit as being part of the related claims, so that collateral estoppel would apply, and the party told the state court, under England, I am reserving my federal claims for federal court. I am not submitting them to you for decision. And the state court replied, his response was, you're in front of me and I'm going to rule on it. And I don't care whether you're reserving them or not. Even if the state court did that and entered a final decision, I think that would not be binding on the plaintiff under England. England would allow him to withdraw that federal claim to the federal court, especially when there is, as here, a case pending in federal court, a case in which the district judge had stayed the action to end, stayed the proceedings in federal court until the state action was over with. And
now, were you representing your client when this happened, or he was representing himself?
I was representing him in the federal action. We had
filed. Was he representing himself in the state court?
He was pro se.
He was pro se over in the state court. But you were representing him, but you didn't show up in the state court.
No.
Isn't that right?
That is correct. I was not representing him on that.
But he initially wanted the state court to rule on the constitutional claims. On the federal constitutional claims, right?
He had raised issues as to what he had raised issues as
federal claim to state court, what he's entitled to do. The state court could rule on questions presented to him. Is that right? In Virginia, you get a state court judge to rule on a federal issue.
In that case, yes and no. He had raised. He had.
A while. You practice law down there around Abington, right?
Yes, Your Honor.
Do you remember Judge Widener?
Your Honor, I certainly remember Judge Widener. I law firm for him. I would have to say he was my mentor.
Well, and Judge Widener was on a case with me one time. We had about a dispute over an incident at a school, and they're trying to raise federal questions. And the decision recited, and I'm going to quote it here to you: school officials have the authority to control students and school personnel on school property, and also have the authority and responsibility for assuring that parents and third parties conduct themselves appropriately while on school property, unquote. Now, would you argue that that's bad law?
No, I would not.
You'd say you agree with me that's still good law.
Yes, yeah. How it is applied, it certainly
And
has.
that's part of what they did here. Your client was disturbing the operations of the school system up there in Loudoun County, which is up there on the Potomac River, right?
Yes.
And the school officials took action to ensure that parents, it's what he was, conduct themselves appropriately while on school property. That's what they would say. But anyway, I noticed that you were down there, and I figured I know you've been around a while practicing law, and I thought you'd remember our friend Judge Wider.
Oh yes. Oh yeah.
On that panel, and he was part of it. That was his part of his work there, and I was on it with him.
And I can see him making that decision. I could also see him saying, but the way that they regulate what parents do on the school property is still governed by the Constitution of the United States. And that's part of what we come to, and I'm kind of going to be jumping around a little bit on the issues. There is a absolute factual controversy as to what Mr. Davidson's behavior was. The Judge Tringa actually, we believe, violated the rules on how to go forward with summary judgment by not recognizing that there was an absolute factual dispute as to what happened and what was done. Now, some of the things that were not in dispute, there is no dispute that Mr. Davidson was never alleged to have gone into the school during school hours, acted up, threatened anyone, made noise, and disrupted teaching. They didn't like the way that he raised issues with him. They sometimes didn't like the manner in which he raised issues with them during public meetings. For example, there in September of 2015, as noted in the letter telling him that he is going to be banned, it was because he showed up at at a PTA meeting and then a back to school meeting, and the principal said she didn't like the way that he handled himself. His testimony was that he was there at one of those and had not participated in the meeting and was leaving because he had a place to go. Actually, a hearing on another case he was involved with the school board. It'll be maybe a FOIA case. And the principal chased him out of the room and followed him down the hallway and accosted him verbally and told them that she was going to have him banned from the school. There was never, and this record, no matter how much you look at it, you will find nothing that he was doing that was disruptive to the schools. And that was a factual issue, which the trial court failed to appropriately gauge and to weigh. As the court ruled that in the retaliation case that the plaintiff did not proper evidence that would carry his causation burden on the retaliation. Look at the 3 letters. They are saying that he is being banned for his expression of his First Amendment speech at the school and to the principal. That he is being banned because his children were handing out handbills protesting the principal's actions on the public sidewalk in front of the school. Truly, a jury could draw the inference that that was the cause, and there was no evidence at all of any kind of disruption by Mr. Davison. Again, going back to Judge Widener would look at the school and say, "What are you doing, and why are you doing it?" He would not have given them any broad claim of right that they could do whatever they want to, however they want to. The second thing, if I may,
Mr. Bragg,
yes,
you're well over your time.
Oh, I'm sorry, Your Honor. I've lost my count of the time there answering the questions. So will reserve the balance of my time.
Okay, thank you, Mr. Bragg. Ms. Judkins?
Yes, sir. Judge Trenga was correct in finding that the principles of res judicata precluded Mr. Davison from attempting to litigate whether or not the school ban violated the provisions of section 22.187 as he pleaded it. You have before you in the record his petition for review. He argued it was an arbitrary, capricious, illegal decision by Ms. Stevens and then upheld by the school board. And the grounds, the facts he pleaded in support of that were violation of his constitutional rights. All of the same claims he made to the district court for arguing that the school ban was unconstitutional. This court has in Lovern said that disputes like this should be in state court and should be filed pursuant to that statute, because that's the appropriate place for them in terms of recognizing that there's a line of cases that I believe appellant is ignoring exactly what Judge King said. The school system by the Constitution of Virginia has the right to control who's on their property, what's going on, disruptive behavior. It isn't just a security threat that's at issue here. It isn't just has he said he's going to shoot someone, has he said he's going to kill someone, has he come on the school property with a gun. It is disruption to the tranquility of the school environment. All of this was encompassed in his petition, and Virginia law requires the court speaks through its orders. At the hearing, he made no reservation. At the hearing, he completely relinquished everything related to the school ban, and by saying, I don't have any claim anymore. It's gone. They let me back. I don't anticipate this is going to happen again. And then in the order, he signed it, seen and agreed, and it was even his order. He prepared and proffered the order, agreed dismissal with prejudice. He made no reservation recognized by law. He abandoned it. And really,
Ms. Judkins, did the district court consider the England issue when it was before Judge Trenga?
The England issue was not raised before Judge Trenga.
Well, has he therefore waived that?
Yes, it's not in. You read the transcript from the argument and his briefs. It was raised for the first time here on appeal. Never gave the district court any chance to review it or look at it. Yes, I argue he's waived it. And this. But
we give a lot of leeway to pro se litigants. You know that, don't you, Ms. Judge?
Yes, but the state. Yes, but I'm sorry.
We can't take advantage of it. We can't allow lawyers,
He had a lawyer.
skilled lawyers on the other side take advantage of it too. So
Well, the
you gotta
state,
overcome that. You got to overcome that burden here too with this point. You understand that, don't you?
I understand, but in arguing to Judge Trenga, he had a lawyer. He was represented when he made the arguments in the district court. He was represented by counsel in the state court. Now, Virginia state court does not give any leeway to pro se litigants. They're expected.
Well, we aren't in the Virginia state court. We're here.
Right. Yeah. So, but I'm arguing that what happened in the state court is a matter of record, and he voluntarily relinquished any claim. Okay. In the district court, he did not raise the England argument, and he was represented by counsel. He had two attorneys, actually. So I argue that he isn't entitled to any inference given pro se's, because in this proceeding, he was always represented by counsel. As Mr. Bragg has admitted, he was represented by him, but he just didn't have him, chose not to have him enter an appearance in the state court proceeding. The res judicata ruling goes to the official capacity claims. There were still individual capacity claims that went forward with evidence developed. The record, I argue to you, is clear that there was no claim for unconstitutional actions by the school system for the school ban, regardless of whether it was official capacity or not. The record shows Mr. Davison created significant disruption at this school. It's an elementary school. These teachers are not like police officers in Fourth Amendment cases who are expected to have thick skin and not get riled by people carrying on and acting crazy and doing things that don't happen. And this is a school, an elementary school. These people like children. They have kindergarten through fifth grade. And Mr. Davison was making threats to teachers, such as, you better not be doing what Principal Stevens is doing, or I'm going to sue you. You're going to find yourself in federal court. Not just that, you're going to find yourself on some crazy website by some woman named Diane Ramovich, or I'm going to get you on that website and they're going to try to interview you. These people who go to college to teach elementary school, they don't buy into crazy parents who are trying to harass them. That definitely upsets the tranquility of the school, such that 2 administrative meetings took place at the school. They had people come down, administrators and the security director, to calm these teachers down and tell them, this is what we're doing to protect you. But they still had teachers complaining, I am being harassed and you're not doing anything, to the administrators. You had then when the ban, you had a principal who didn't decide on her own, and this dovetails into the qualified immunity argument. She didn't decide on her own to ban him. She didn't know how to ban anybody. That's the record. She had to speak to Virginia Patterson. She had to speak to Patterson's supervisor, Dr. Martin, and the school board division council. He wrote the letter. He just told Stephen she had to sign it. She didn't even want to sign it, but she was told she had to. Well, now you know from the record there's a more formalized system, but it had started then. Before that, those letters went to Mr. Davison. They were reviewed by administrators, and there were meetings with staff to try to calm them down. It didn't work because Mr. Davison just wrote more horrific emails to these teachers. I want you to meet me off campus so I can talk to you. They're not going to meet him off campus. I want you to do this. I want you to do that. He was making social media postings, derogatory postings about the teachers and the principal. That was disruptive to the school.
Would you want us to decide this case on the basis of qualified immunity, or on the basis of whether there's a constitutional violation?
Well, I think you can decide it on qualified immunity under Pearson, and the judge decided. We can take either prong in whichever order we want to.
And I'm just asking you as counsel for the defendants, who you're the only one that's asserting qualified immunity. Do you want that resolved? You want it resolved on qualified immunity, or you want to put that aside and have it resolved on whether or not there's a constitutional violation been shown?
I want it resolved on both. There's no constitutional
Well,
violation.
we don't have to resolve it on both. If we resolve it in your favor on the lack of merit to the claim, then there's no issue of qualified immunity.
Yes,
You never reach qualified immunity.
right.
If there's no constitutional violation shown, you never get to qualified immunity. If there's a constitutional violation shown, then, or you assume one, then we have to decide whether the law is clearly established and whether they're entitled to qualified immunity anyway, even if there's a constitutional violation.
Yes, sir.
But we can do either one. There's a case called Saucier, and I may be pronouncing it wrong. That's a French word. I'm not very good at that, but that tells us, that's from the Supreme Court of the United States, that tells us we can take either prong of that thing and decide it, or take either one first and deal with it that way. And I'm just asking you because you're here, the one that's asserting the qualified immunity issue.
Yes, but I do not want to concede there was a constitutional violation or that issue.
You would, and you probably wouldn't want us even to assume there's a constitutional violation. You'd rather have us decide, I suspect, that they've taken the best look we can at this thing, looking at it in Davidson's favor, there's no constitutional violation shown. But I was just trying to give you an opportunity to say something like that, because you brought up qualified immunity.
Oh, I see what you're saying. I'm sorry. Yes, I am relying, I want the court to find there's no constitutional violation based on the record, based on the case law that was in effect and still in effect at the time, as you pointed out. And even if there were any constitutional violation, the individuals that he sued for this, in the individual capacity claims, entitled to qualified immunity. The case law, honestly, I think the case law went in favor of my clients based on Lovern and the other, and the Edwards, Prince William County case, the cases that talk about how the school system really can control who is on their property. These are not, this is not an unusual circumstance where or isolated circumstance where a school system has banned someone for causing disruption. And the disruption is evident. The disruption is evident. Even Mr. Davison admitted in his deposition that he liked to get people's attentions, although this was about the school board meetings. He likes to get people's attention by talking really loud, getting confrontational, acting in the behavior. He cited the example of the late Elijah Cummings as his example of how he wanted to get people's attention in the school system. So yes, I am stating.
And you took that to represent that means he was what?
No,
excuse me. You said that he represented himself as Elijah Cummings being, I guess, a prototype or model of. And you said, what does that mean? You said, therefore,
well, what? I wasn't. That meant nothing to me. It was
you brought it up.
Right.
That would be an example of what kind of the level of disturbance he was interested in, or his motive, or the way he made himself heard. You brought that up. I'm asking you, what do you mean by that? By saying that
he went beyond that. It was beyond Elijah Cummings.
Oh, beyond. Okay.
Right.
What is referencing Elijah McCummings?
He said it in his.
I know he said that, but your counsel, and you're here, you wanted to convey to us that must be some example of the level that he sought or modeled to. And I'm asking you how.
Well, he didn't. Well, I brought that up because he didn't act like Elijah Cummings.
You didn't say that.
Well, he went beyond it, though. The words he went beyond and said he wanted to be.
By that.
He thought he was being. an advocate. He thought he was being an articulate advocate. He thought he was doing things like
well, his children go to that school, right?
Yes, they do.
Well,
they did.
And you contrast that this is not a high school, this is elementary from the teacher's perspective, but I would submit that is elementary school where you get the most parental involvement sometimes, and sometimes exercise. And if there's any indication of what that might look like, what's going on in our country now, you see a lot of people are very interested in what's going on in schools with their children and have something to say, and they're objecting to a lot of things in terms of restrictions and all those things. So, you know, you use the term, these are your words, you say crazy. I mean, I'm quoting you this morning. You know, you use a lot of terms in terms of negative adjectives toward him. But he's a parent, and he had some concerns. And sometimes people who need to be heard, society passed them by, they're voiceless people. And until that they raise it up a notch, I'm not talking about violence, but I'm talking about because they sometimes become people who some people call irritants. They're told once, no, and then some people said, no, I'm gonna come back again until I get a more reasoned response. So he's not a trespasser in the sense that some interloper, but you're right, there's a balance. School has to be that. But just interesting, you kept going on, and then you brought the late Representative Congressman Cummings, and then I just understand where are you going with this in terms of that?
Well, he wasn't acting like.
But you didn't say that. You didn't say that at all. You used that. You said that was. But anyway, well, let's get to this. Let's get to this. What about retaliation? We're on summary judgment, and all reasonable inferences to be drawn in favor of the non-moving party. Correct?
That's true as a standard of review.
All right. Yeah, that's what I was given to you for. That's a standard review.
Right.
Okay. All right. Now, there's this claim against Stevens that in retaliation, he made a report, CPS. Is that right?
Yes, he makes that claim.
And that's because they saw his children passing out flyers. You made a complaint with Child Protective Service?
No.
Or report or something like that?
No, the record shows that 2 teachers came to her with concerns about their being neglected. Hygiene, bringing the proper, not having coats when it was cold, not having proper footwear, yes, and embroiling them in handing out these flyers about the principal. She's a mandatory reporter. She sought legal advice before she contacted CPS, Division Counsel. I argue that there's no evidence.
Those are facts. Those are facts. But we're talking about all inferences drawn. There's certainly a temporal connection with his complaints and that report, and also that the flyers were negative to whom?
The principal.
Right.
They weren't just negative.
Well, the point is that I'm just saying negative. I don't want to use all these addictive things you use in terms of, they were negative, and it's in record how negative they were. But how do we say as a matter of law that wasn't connected in terms of retaliation?
Judge Trenga found on the record and stated that the reason he was banned from the school was not because of what he was saying. It was because of his conduct.
No, I'm talking about retaliation based on making the report to CPS now. How do we know as a matter of law that was no connection with retaliation in that? That's what I'm saying. Because
the facts that were uncontested as to why the report was made to CPS were not disputed by Mr. Davison with any affirmative evidence. He didn't come forward with anything to dispute that the children's teachers raised concerns that they did not come to school with the correct clothing at times. Their hygiene was at issue. and that they were concerned about the flyers. Even the mother told him to stop having the children stand around handing out these flyers. The mother told him to stop doing that.
I'm saying that, but it's a question of fact, isn't it, as to which was the driving motive? Well, my point is this: yes, it could be true that the coats weren't worn, in their view, consistent with the temperature, or you said hygiene. You said find that no, the principal reason was the principal, not principal, but the main reason was that they were retaliated because he had negative things to say, and you said it was more than negative. So these things, and that was the driving reason. How do we know as a matter of law that's not the case? That's an inference that's drawn on behalf of the moving party there, isn't it?
No, all he has said is I was retaliated against. He has not produced affirmative evidence to dispute what our record shows. If this case were to go back and be tried, this is 2015 when this was happening. And this principal, and then a jury's going to decide whether the school system properly banned Mr. Davison.
No, I'm talking about the retaliation claim.
The retaliation. Yes, I argue that the record doesn't support even an inference. Just him saying he was retaliated is insufficient given the entire record of what you see. And I don't want to waive anything in my brief about the school board meetings, Facebook, defamation, and I'm out of time.
Well, you're talking to me, so I'm the chief.
Okay.
So I think you're okay. I'm asking you a question.
You're the boss.
Well, I'm not the boss. I'm the chief of this panel, of the court.
All right, right. You're the boss of me.
What did you say, counsel?
I said you're the boss of me in this terms of this argument.
Don't use terms like that. I'm not the boss of anybody. I'm the chief of the United States Court of Appeals for the Fourth Circuit. I'm asking you questions.
Yes, and I appreciate that.
I'm not your boss or anybody else's boss.
That.
All right. What I'm asking, what I'm saying is that in terms of retaliation, you said we do that. We do it in Title VII many times, and that is we can't get into so much head. But the question is, in terms of fact question of retaliation, when you're making these statements, negative statements about someone, and then in a matter of how many days passed between the flyers and the report to CPS?
I don't recall off the top of my head. I'll be honest. The record is.
But you would suggest that you would probably say they're very close in time. Your recollection?
No, actually, I don't think they were necessarily very close in time. I really don't remember, but no, I don't think they were necessarily.
More than a month. Well, maybe Mr. Bragg will help us with that.
I'm not really sure how close in time, but retaliation has to be the but for him saying negative things about her, she wouldn't have made the CPS complaint. The CPS complaint didn't just come from her. It came from two other teachers as well. The process is, under Virginia law, the principal puts it in to Child Protective Services and they decide whether to investigate. So the complaints about him and how the children were being either neglected, or there's other things in the record about things that he wrote on notes to them. All of that went to CPS. And the record that went to CPS is in the joint appendix, what was actually sent to them. And what was actually sent to them was multiple things. So, but for causation, Judge Trenga found also there's no but for. But for him handing out those flyers, she wouldn't have made the CPS. No, that was not the main focus of the CPS complaint. They thought the children were being neglected by him on a personal level. And that's when CPS complaints are made. They're mandatory reporters. So they have to err on the side of protecting the children. So, I mean, I think there is evidence they were being neglected, these children. So maybe not to the level that CPS is going to take any action, but that's up to CPS. If my principal and the others at the schools didn't, she did that based on advice of the division council. So if there's no but for causation, and regardless, there's no evidence she did it because of any malice or anything. And I think she should be entitled to qualified immunity as well because of the unique circumstances here.
All right.
All right.
Thank you, counsel. Mr. Bragg?
Thank you, Your Honor. And just very quickly, just a few things. One, we did litigate and raise the England reservation before Judge Tringa. Judge Tringa specifically ruled on the England reservation. So to suggest today that it was not raised by Mr. Davison in district court is, I don't know where that comes from. Secondly, I would also bring to the court's attention that with regard to Principal Stevens, that during the pendency of the ban from the school, which of course included anything that happened at the school, Mr. Davison wanted to go to his daughter's musical recital at the school after hours, asked for permission. There was a meeting, and I believe Dr. Patterson was involved as well as Principal Stevens. And according to Mr. Davidson's testimony, it was acknowledged that he had not been a danger to anybody at the school. It was recommended that he would be allowed to come back to the school, but Principal Stevens said, as long as you keep your mouth shut and don't raise these issues with the teachers and with the other parents, because that's trouble, all these things that you were raising and saying, including things about her. And then finally, as the court has observed, is that when you're looking at retaliation, you're looking at the full context and all the inferences that can be drawn. Yes, how the school system responded to Mr. Davison, seeing him as disruptive, was displayed today. Elijah Cummings, anyone who would speak with passion and with sincerity to a system that would not listen, anyone who would advocate for those who needed help, who couldn't speak for themselves, would be considered a disruptor that needed to be quietened. And that is the reason that Brian Davidson was quietened, because he was effective, because he was passionate, and because he was strong in his principles, brave in his heart, and was willing, like someone similar to Elijah Cummings, to stand up and say, stop, change your ways. They did not want to hear that, so they shut him up. If the court has any other questions, I would submit our case from there.
No, I just want to respond. Rebuttal is to rebut some. The question, you brought your claim of retaliation as to the CPS. Are you saying there was no facts there, or is that?
Oh no, I'm saying that that's part of the overall.
No, but I'm asking you about that particular claim, CPS.
As my memory of the record is, Your Honor, there was some lapse of time. If you're asking, was it immediately after the report to CPS that the ban occurred? It was, I think, within during the previous year's school year.
Okay.
It was not within.
So
yeah.
Within what?
Yeah, it was not within a week or two or a month.
Oh, okay, all right.
That's my understanding. Essentially, the ban occurred.
So why do you? When if it's not, then I thought my understanding was that there was some temporal connection, whatever that. But then why is that still a claim? I mean, what would if you don't have the temporal aspect? Mr. Counsel, your colleague on the other side, Ms. Judkin, says that there are other reasons. There was hygiene. there was a disconnect with the clothing and the apparel wasn't fitted with the season. Why isn't she correct on that? She put it in the but for, I'm not sure that's quite the standard, but I think it can be a substantial reason without a race ipsa type reason. But so. Go ahead.
Mr. Davidson's evidence would be that the complaints that were made to CPS was done merely to punish him and harass him, and that there was no factual basis for it, that when CPS looked at it, that's what they told him. We find nothing. There is nothing here. I think part of the claim was that at least the way it was reported to him was not there was a problem with hygiene. It was that they wore rain boots to school on a day it wasn't raining. Not that they didn't wear rain boots on a rainy day, but that they wore rain boots on a day it wasn't raining. And in the context of everything else that was happening, that shows the animus that had developed toward him. In the spring of 2015, during the previous school year, that before he was banned, there was discussions of banning him. That is the evidence. There were threats to ban him. There were some of the school board members saying, we don't think we could do that. That's punishing him for what he's saying. That'd be unconstitutional. There's evidence of that. And then it walks through the summer. After the school year, nothing happens. You're starting the new school year, and then he's banned. Yeah, in all of the context of everything else that happened, including the report to CPS, shows the animus and what they were doing and why they did what they did.
And for a parent, that's a pretty serious report, isn't it?
It's a terrible report. He is a former naval officer. Has a master's degree from MIT. He works in information, computer information, for a defense contractor with a high security clearance. He goes to work on computer systems, as I understand it, at the Pentagon. And having allegations like that made against him affects his life absolutely. And very serious. It's very serious to tell a man that he can't go to his daughter's choir or orchestra recital. He can't go talk to the teachers for parent-teachers conferences. Why? Because of what he is saying at a PTA meeting, supposedly. Speaking out, bringing questions to light that he was usually substantiated in by other public officials, including winning FOIA lawsuits against the county, investigations done by other agencies because of his complaints. He was more than just a gadfly. He was a gadfly who was causing there to be serious progress toward making the system better in the Loudoun County schools.
All right. Thank you, Mr. Bragg.
Thank you, Your Honor.
Thank you, Mr. Judkins. Appreciate your arguments. I wish we could come down and greet both of you. You acquitted yourselves very well, both counsel. Great job, and thank you so much for helping us on these very difficult cases. And I wish you well, and be safe. Thank you.
Thank you.
Mr. Newton?
Good morning. May it please the court. Time permitting, I intend to address two issues today, two main issues. First, whether there's extraterritorial jurisdiction over the sole count in the superseding indictment under 18 U.S.C. section 1956F. And secondly, whether the admission of appellant's confession and incriminating evidence seized by FBI agents from his cell phone violated the Fourth Amendment. And I will address those both with respect to the plain error version of the claim and the ineffective assistance of counsel version of the claim. I'll begin with the extraterritorial jurisdiction issue. I want to address three sub-issues. First, the applicable standard of review. Second, the fact that section 1956F is a jurisdiction limiting statute. And third, application of the lingering doubt standard, which is a component of the presumption against extraterritorial application of a statute. Regarding the standard of review, this court should engage in de novo review and not plain error review of the statutory interpretation issue for three separate reasons. First, the district court ruled on this issue after briefing and an oral argument, wrote a written published opinion on it. Second, analogous to the issue of whether civil diversity jurisdiction exists under 28 U.S.C. section 1332, the issue of whether extraterritorial jurisdiction exists under section 1956F unquestionably is an issue of subject matter jurisdiction. The Supreme Court's decision in Arbol in 2006 explicitly says, if a statute uses the word jurisdiction, it is referring to subject matter jurisdiction. And they drew the analogy to 1332. Well, 1956F is very analogous to 1332, and therefore it can be raised at any point. I did raise it in the lower court, but I'm also permitted to raise it for the first time on appeal, and it should receive de novo review. This is not a merits issue. This is a subject matter jurisdiction issue. And then finally, even assuming for the sake of argument that plain error review does apply, the Supreme Court in Fowler versus United States made it clear that in addressing a threshold statutory interpretation issue that relates to, assuming this is a sufficiency of the evidence as opposed to a jurisdictional question, you should engage in de novo review of that threshold statutory interpretation issue as the court did in Fowler. Finally, even if this court were to apply a full-fledged plain error review standard, the error is plain based on the Supreme Court's well-established rules concerning extraterritorial jurisdiction of a jurisdiction-limiting statute. Section 1956F is such a statute. It explicitly limits, it does not create jurisdiction. The government and the district court and a couple of other courts around the country that have interpreted this, and there have not been many cases, they've all just assumed this statute gives jurisdiction. It does not. It limits jurisdiction. The Supreme Court in Microsoft said that the presumption against extraterritoriality, including the all-important lingering doubt standard, remains instructive in determining the extent of the statute. So we're talking about applying the lingering doubt standard to a jurisdiction-limiting statute. If there's any doubt after reviewing the text and the legislative history of that statute, there is no extraterritorial jurisdiction. We're not dealing with an ordinary criminal statute where the government's trying to apply it in an extraterritorial manner. That's what most of these cases involve. This is different. This is a jurisdictional limiting statute, and that's the key that needs to be.
Were there victims in the United States?
Yes, Your Honor.
And they were part of this offense is a single count of a money laundering conspiracy. Part of it, at least, maybe the most important part, occurred within the confines of the United States, correct?
That's true if it were a substantive offense. Under Whitfield,
well, it's a conspiracy. One count. Part of it occurred in the United States. Part of it occurred overseas.
If this was
to me, what you're arguing for is that they can't use the evidence of what occurred overseas. They can only use what happened in the United States. These things cross international borders, my friend.
Your question, Your Honor, is a good one.
I'm not so sure that this is not just a red herring, what you're talking about.
Well, here's the problem for the government. Here's the problem for the
And the government says that in their brief, and Judge Grimm sort of says it too, in his opinion. He wrote a big, long opinion on this thing.
He actually didn't discuss this issue very much. He discussed another issue.
The government's not hard from, if government, to prove a conspiracy, they're not confined to the evidence of what happened with respect to it in this country. They can prove it occurred in 100 more countries if they want to, or if they're able to, and if it did occur.
What Your Honor is saying would be true if they had if the government had charged.
I'm saying it isn't true. I don't think I'm off base much on this.
Well, here's the problem.
I've been around this criminal business for a long time, and
so again, we need to turn to the language. Turning to the language of 1956F, which the court has to look at the text as well as the legislative history. It says, in the case of a non-United States citizen, and it also refers to the statute only applies to the conduct prohibited by this subsection. That has to mean what you're charged and convicted of. It can't mean other things. It's basic that you have to have, and it says in the case of, which the Supreme Court says that's a prosecution or a cause of action. So the only thing that matters here is the conspiracy charge. And Whitfield said very clearly in 2005 that the only elements of money laundering conspiracy are the formation of an agreement. There is no overt act requirement. There's no transaction requirement. It's
no overt act requirement, but you can lose a lot of evidence in proving the conspiracy, my friend, of what went on.
You certainly can offer that at trial. I'm not saying the government couldn't offer that in a conspiracy.
You have to prove the crime. The government can offer whatever evidence they have, wherever
they
it comes
can.
from.
But just like the categorical approach,
wherever.
Just like the categorical approach, the court is limited to the elements of the offense. Whitfield says the elements are a formation of a criminal conspiracy. That's it. No conduct, no actions, nothing along those lines can be considered as an element. Now, proving it's a different story, of course. People prove conspiracies by proving the substantive offenses all the time. But the language of the statute says there is extraterritorial jurisdiction over the conduct prohibited by this subsection. That has to mean you are limited to looking at what's charged in the indictment. They did not charge him with a substantive offense under 1956A. They solely charged him with a conspiracy offense. The statute that we're talking about here was written in 1986.
Have you given up this claim on the superseding indictment?
No, I'm not giving it up. I'm just putting my powder in what I consider my best claim.
You think these other two issues are your strongest?
No, I'm going to address the Fourth Amendment. I have time.
You're going to rely on the brief on the statute of limitations.
I'm going to rely on the brief on the statute of limitations. I believe it's adequate.
All right.
So if I could go back to the extraterritorial jurisdiction issue. So you've got to look at each part of 1956F. So over the conduct prohibited by this subsection clearly means what you're charged with. It cannot mean what evidence was offered. This is like the categorical approach. Secondly, in the case of a non-United States citizen, the conduct occurs in part in the United States. In the case of means in the prosecution of. That's the only way to interpret in the case of. Even if it's ambiguous, this is also very important. Under the lingering doubt standard, this is not the rule of lenity. I don't have to show a grievous ambiguity. I only have to show any doubt. And if there's any doubt, either in the language, the text of the statute, or in the legislative history, we win. That's the strength of the lingering doubt standard. So there are two parts I really want to talk about here now. One is the term, the conduct occurs in part in the United States. We spent a lot of ink in our briefs fighting about what that means. At the very least, it is ambiguous based upon Whitfield. This is very important to understand.
That's clear as the bell. Conduct occurs in part in the United States.
The American citizen co-conspirator conduct.
Plain as it can be.
So there is no overt act requirement. Therefore, what a co-conspirator does or doesn't do in the United States is irrelevant to the elements of the offense. The sole elements of the offense for this statute, unlike a traditional 371 conspiracy, is the defendant agreed to commit a crime. There's no question that was solely done in Nigeria. Appellant did not enter the United States for, I think it was 2 years after the conspiracy ended. He came on an F1 student visa, and that's when they arrested him.
A person agree with themselves, they got to agree with somebody else.
Correct.
Some others.
Correct. But
you don't one person conspiracy, my friend.
I understand
You
that.
don't.
But a person,
Right.
In the case of a non-United States citizen means you're looking at the non-United States citizen's conduct. You're not looking at a co-conspirator's conduct. At the very least, there
What
is.
one conspirator does under settled principles of conspiracy law, what one does, they all do.
That's
What
true.
one does, they all do. The
That's-
agency relationship governs that. What
That's-
one conspirator does is attributed to everyone else who was a conspirator at the time the act occurred, wherever it occurred.
That is true in a traditional 371 conspiracy. It's not true.
That's true in conspiracy law in the federal courts, as far as I'm concerned.
It is true
I
for purposes of looking at
I've
traditional
tried,
conspiracy.
I've tried dozens of these conspiracy cases.
You've got to filter that. Your Honor,
On both sides.
you have to filter that through Section 1956F. It is a jurisdiction limiting statute. If there's any doubt that Congress was at all unclear about what this means, and there's clearly doubt for this reason. That statute was written in 1986 before the conspiracy statute provision was added to the money laundering statute. It was never amended thereafter. It was written for a substantive offense. It was not written for a conspiracy offense. There's another reason. 1956 F1(2). It requires also for extraterritorial jurisdiction, it requires there to be a transaction in at least 10 or in excess of $10,000. There is nothing in the conspiracy statute requiring a transaction. There's nothing. You can just agree to do a money laundering offense and you've violated the law. Again, the government's, what they're trying to do is they're trying to put a square peg of a substantive extraterritorial offense statute, which was written in 1986 when there was only a substantive offense in 1956A. And they're trying to put the conspiracy into that square peg into a round hole. It doesn't fit. Transaction is not an element of conspiracy, nor is conduct. Even if what Your Honor is saying were to be filtered correctly through 1956F regarding F1, it doesn't work with F2. Again, this statute puts extra things on the government to prove to be able to exercise jurisdiction. So traditional conspiracy principles and Pinkerton and all of that, they don't apply to 1956F based on its express language. And then you also have to look at the legislative history. So if you look at the Senate report, which is the leading thing, it says that the statute's intended to limit jurisdiction. It is not the committee's intention to impose a duty on foreign citizens operating wholly outside of the United States to become aware of US laws. Mr. Ojokin was entirely outside of the United States during this time. It's not talking about co-defendants in the United States or co-conspirators. It's talking about defendants where the government's trying to exercise extraterritorial jurisdiction. They have to do something. And in a conspiracy under 1956H, you don't have to do anything other than agree. You cannot therefore exercise extraterritorial jurisdiction over somebody in that situation. They could have charged him with aiding and abetting a substantive count. They did not. They only charged him with conspiracy, and they're stuck. They're stuck because there's ambiguity at the very least in 1956F. Briefly, the Fourth Amendment claim. The law and the facts are clear. It was not raised in the court below. I'm arguing it as plain error. I'm alternatively arguing it as an ineffective assistance of counsel claim. Payton versus New York versus Harris, and Jardines versus Florida all stand for the proposition that what happened in this case was an unlawful entry into a home without valid consent, or alternatively staying beyond the limited scope of consent given. There was getting the confession and getting the cell phone contacts after the Iron Curtain, so to speak, had fallen on the Fourth Amendment. It's all tainted fruit. New York versus Harris makes it very clear the remedy is suppression. The government's attenuation arguments don't work. The remedy is suppression. The law was clear, the facts were clear. Therefore, it's both reversible as plain error, and alternatively, this is one of those rare cases where it conclusively is shown on the record deficiency, and I discussed the prejudice in my brief. Thank you.
Thank you, Mr. Newton. Mr. Pelletieri.
Thank you, Your Honor, and may it please the court, John Pelletieri on behalf of the United States. The prosecution of Mr. Ojedokun for money laundering conspiracy was proper under either step 1 or step 2 of the framework for evaluating extraterritoriality that the Supreme Court has set forth in a number of recent cases. Step 1 asks whether there has been whether the presumption against extraterritoriality has been rebutted. So the presumption is that Congress intends to only legislate for conduct that occurs within the territorial jurisdiction of the United States, but then, so that's the presumption, and then the court looks, using all the tools of statutory interpretation, to determine whether there's a clear indication that that presumption is rebutted and that the statute does apply to extraterritorial conduct. Here, there is an express extraterritoriality provision in 1956F, and it provides, as relevant here, that there is extraterritorial jurisdiction over the conduct prohibited by this section if, in the case of a non-United States citizen, the conduct occurs in part in the United States. So there are two questions. Number 1, what is the conduct prohibited by this section? And number 2, did this conduct occur in part in the United States? Because it's undisputed that Mr. Ojedokun is a Nigerian citizen. So the conduct here is a money laundering conspiracy prescribed by 1956H. Now, a conspiracy, the Supreme Court has made clear that the actus reus of a conspiracy, even one that does not require proof of an overt act, is the criminal agreement. That is the actus reus, it's conduct. That is it's a partnership in crime, a criminal venture. And that criminal venture.
So let's get good. I like the way you started in terms of getting some staging this. You're saying the mere agreement is conduct?
Yes, Your Honor. And I would.
How could that be? You mean so? Are you just having a conversation with someone? That's conduct.
It is a criminal conspiracy. It's an agreement toward a partnership in crime.
But see, here's the thing: is that you're saying that talking to someone and they're agreeing with what you said is conduct?
Absolutely, Your Honor. And I'll point you to the Shabani case in the Supreme Court, 513 U.S. 10 at 16 says, the prohibition against criminal conspiracy does not punish mere thought. The criminal agreement itself is the actus reus and has been so viewed since Regina v. Bass, which is a 1705 British case. And this is fully consistent with the law of venue. The law of venue looks
Well, if that's the case, then there's no limitation to this extraterritorial. That means that no one has to be in the United States other than one person on the phone, and you spoke to them, and you're a non-citizen, and you agreed. You're saying that's enough. That's
if you
enter the agreement on the phone.
Yes. If you enter into a criminal conspiracy, if some person is in Nigeria and another person is in the United States, that criminal agreement has occurred in both Nigeria and the United States, both places. It is a criminal partnership in crime among individuals in both locations. And that is fully consistent, Your Honor, with the law of venue. I mean, the law of venue asks, the Constitution says that crimes have to be prosecuted where they have been committed. And then to determine where the crime has been committed, the Supreme Court said in Rodriguez-Moreno that a court must initially identify the conduct constituting the offense and then discern the location of the commission of the criminal acts. And this court said in Smith that venue is proper only in a district in which an essential conduct element of the offense took place. And
right, you just said conduct element, but there is no conduct element to conspiracy for money laundering.
But Your Honor, this court and every court has concluded that venue for conspiracy is proper in any jurisdiction where one of the co-conspirators is present at the formation of the agreement, because that is where the conduct occurs, in any jurisdiction where the defendants are present, where the co-conspirators are present.
Yeah, but normally, I mean, in terms of most conspiracies require some act in furtherance. You agree, true, everyone in the conspiracy.
But Your Honor, this court has said that a conspiracy offense takes place, and this is in Bowens, and you said it in Levy Auto Parts, we cited in our brief, that wherever the agreement was made, and that's here in Nigeria and the United States, or wherever any overt act in furtherance of the conspiracy transpires. So there's two ways of evaluating the location of a conspiracy. Number one, the location of the conspirators at the time of the formation of the agreement, and the conduct for the conspiracy takes place in every single one of those jurisdictions at the time of the formation of the partnership in crime. And number two, wherever any overt act in furtherance of the conspiracy takes place. And this court has applied, and the Supreme Court has applied that in Whitfield itself, in a case where a conspiracy statute does not require as an element proof of an overt act. Nonetheless, even though it's not an element, overt act is not an element, that conspiracy, the conduct occurs in any place where overt acts in furtherance of the conspiracy take place. And that is fully consistent with the—
Yeah, but you're arguing in circles now. You're saying venue is appropriate wherever the act occurs. That's true. But we got to get back to the front end. No act or conduct is required for conspiracy for money laundering, right?
Your Honor, the actus reus, an actus reus is an act. That is the definition of an actus reus.
No, the actus reus in a sense is the bad thing.
No, it's the act and not the mental state. So an act, and the Supreme Court has said, the actus reus, quote, actus reus of a criminal conspiracy is the criminal agreement. Two people come together, and we cited also—
Well, that's generally so, but has it ever been said that in the sense that means that for money laundering is a little different? It's kind of a different type of conspiracy, isn't it?
No, Your Honor, it's not. It's the same. And in Whitfield, I think the court said, look, this is effectively, by not the language of the statute, effectively encompass common law conspiracy. So that did not require an overt act. And this is longstanding law that a conspiracy involves conduct that is the agreement, at a minimum, the agreement. And in addition, overt acts in furtherance of the agreement, but at a minimum, the agreement. And that conduct, the agreement, the criminal partnership, occurs wherever individuals are present at the formation of the agreement. And it's undisputed in this case that there was a co-conspirator present in the United States, in Maryland, throughout the entire agreement, its formation, and throughout the entire criminal conspiracy here. And that is why the conspiracy occurred under the plain language of the statute, occurred in part, just has to occur in part, in the United States. Now, for the same reason, and for very similar reasons, step two of the extraterritoriality framework also establishes that the prosecution of Mr. Ojidokun was proper in this case. That inquiry looks, what is the object of the statute's solicitude? In other words, its focus, which can include the conduct it seeks to regulate, the parties and interests it seeks to protect or vindicate. And if that conduct relevant to the statute's focus occurred in the United States, then the case involves a permissible domestic application. And we've cited all these cases going back to Ford in the Supreme Court that have held that a criminal conspiracy, there's jurisdiction in the United States for a criminal conspiracy when there's an individual who's present in the United States, when it's formed, and when there's overt acts in furtherance of the conspiracy take place in the United States. That also is long-standing law that establishes that the solicitude of the object of the statute's solicitude, the criminal conspiracy, the partnership in crime, the collective criminal venture occurred in the United States, and that is what is being prohibited here. That's the focus here, and it occurred in part, sufficiently in part, in the United States, so that this is a domestic application. So whether you look at it through the lens of the express extraterritoriality provision in 1956 F, or under step two, under the framework, this is a proper prosecution of the defendant here. And I'll briefly, and now for all those reasons, this court can simply assume that the review is de novo and affirm for these reasons. But it's our view that Mr. Oshidokun needs to satisfy the plain error standard. He failed to preserve this claim. And Mr. Oshidokun has raised a few reasons why he thinks.
Well, jurisdiction can be raised at any time, can it?
Subject matter jurisdiction can, Your Honor. And the Supreme Court in Morrison made clear.
So why are you trying to argue?
Your Honor, in Morrison and in all the cases following Morrison have made clear. So in Morrison, the lower court said that
if we don't have any jurisdiction, we don't have any jurisdiction.
Your Honor, this is not a matter of subject matter jurisdiction.
Maybe I may be simpler than some of you.
Your Honor, I don't
know how you get plain error out of. We can recognize that or obliged to, even on our own, if none of the lawyers ever raised jurisdiction.
Your Honor, I would direct the court to Morrison and this court's application of Morrison and Harris. Both of them are cited in our brief. What happened in Morrison was the lower court, the Second Circuit, treated the extraterritorial reach of a statute as a matter of subject matter jurisdiction. And Justice Scalia's opinion in Morrison said no, that's just wrong. The subject matter jurisdiction goes to the power of the court to adjudicate, and the court had a power to adjudicate whether the scope of the statute. What the issue here, it's a merits question as to the reach of the statute. And
well,
every court.
He said it really wasn't jurisdiction.
Right? I'm sorry, Your Honor, I couldn't hear you.
So, well, I'm sorry. It sounds like he said it's not really jurisdiction. It's on the merits.
Yes, exactly. That's what Morrison said, and that's what this court said in Harris, where it said, okay, because the extraterritorial reach of a statute goes to the merits, then it's subject to all forfeiture and waiver and procedural default rules. And so that's in Harris. And all the courts have applied that. So we cite cases where courts apply plain error.
If you look at it that way, you can do it, I guess.
Yes, yes, Your Honor.
I got another question. That fellow, your colleague there on the other side, didn't argue his superseding indictment claim. That you're satisfied with your brief on that and Judge Grimm's ruling?
We are satisfied, but I'm happy to go into it. The issue here.
I'll just let you rest on your brief if you want to. I just want to make sure that you're satisfied. You don't need to argue it too.
Well, Your Honor, I'm happy to go through it, and maybe if the court has questions, we can discuss those. I mean, the issue is whether the superseding indictment relates back to the original indictment, and the standard there is what.
And Judge, you all said it did. Judge Grimm said it did, and they say it didn't, and they brief it extensively. But then he didn't argue, and I just didn't want you to get mousetrapped by it. Because anyway, I thought it was interesting. And the other question, they claim an ineffective counsel. And this is a direct appeal, but they do have a claim of ineffective counsel against somebody. Do you know which lawyer they're talking about?
I believe it would be the trial counsel, Your Honor, for failing to.
I thought there were two of them. There was one lawyer, and then they got then the public defender came in.
I think the defendant was represented by, I believe, CJA counsel at trial. I don't know if I believe that earlier the federal defender may have been initially appointed. I don't know the answer to that, Your Honor, but I know at trial and at the time when the suppression motions were filed, the defendant was represented, I believe, by a CJA lawyer. And that's the moment when any kind of suppression claims had to be filed before trial at the deadline set by the district court. And in our view,
right.
Yes.
Go ahead.
Oh, sorry, Your Honor, but couple points. I mean, as to the ineffective assistance claim, this court has never permitted a remand for additional fact finding. It has identified 3 different ways that a defendant can raise an ineffective assistance claim. One is in a Rule 33 motion in the district court. That wasn't done here. It's not at issue. Number 2 is on appeal if it's conclusive from the record that there's an ineffective assistance claim, and that is just not the circumstances here. And then number 3 on collateral review under 2255. That is when,
it's normally a thing for collateral review. I was trying to figure out who was supposed to be constitutionally ineffective, but you don't know either.
well, it's the CJA lawyer. I don't know his name, but the CJA lawyer who represented Mr. Oshidokun in the district court at the time he filed his.
Well, we got a CJA lawyer now.
No, he's not here now.
Well, there's a CJA lawyer on appeal, in the appeal. How many lawyers does this fellow have? Can you tell me that?
I believe at least 3, but I don't know definitively, Your Honor.
Okay, all right. That helps because I do it just 2, but it wasn't clear to me. But we shouldn't be reaching any of that stuff. That's for
Absolutely, Your Honor.
review.
Yes, you should
Yeah.
follow this.
Government's position. That's the normal position, and that's normally what we do.
Yes,
Okay.
yes. And briefly, just the suppression claim is, in our view, is fully waived. It's not. There's nothing for this court to review because the Rule 12 requires that a defendant file a suppression motion and raise any suppression claims prior to trial, and a district court can, or a court, it says, can consider a suppression claim subsequently only if the defendant establishes good cause. And the defendant here.
The district court fully considered this and ruled in your favor.
No, Your Honor, there was no consideration of the suppression claim in the district court. It was raised for the first.
I thought he ruled that everything was all right in his memorandum of opinion.
Yes, he did, Your Honor. And then on appeal, Mr. Oshidokun is raising an entirely new suppression claim that he did not raise in the district. Yeah.
All right. Okay.
And that claim under Rule 12 is barred for any review, plain error or otherwise, because there's been no attempt to show good cause, let alone a showing of good cause. And we cited the cases that we do recognize that there's disagreement among the courts of appeals. Some courts will allow appellate review on plain error without showing good cause, but the majority view and the view what we believe is correct is that a defendant must show good cause either in the district court or the court of appeals, and that if the defendant does not show good cause, there's no appellate review of a suppression claim on appeal. And this court has left it open. It has not gone one way or the other. I can say, like most recently in the Fall case, which is 955 F3rd 363 at 373, the court did make clear that it's an open issue in this court. We did cite cases that have applied the waiver rule, but there are also cases where the court has reviewed for plain error. We think that the reason the court did that in those cases is because the government didn't assert waiver, and so we essentially waived waiver. But we're not waiving waiver here. We're asserting that the defendant has to show good cause, and therefore you cannot review the suppression issue. But even if you were under a plain error review, there's no error here, let alone plain error. There was consent to enter the home. It's not clear or obvious on this record that the consent was not knowing, and that the interview was within the scope of the consent. And even if you assume that there was no consent and that the intrusion into the home somehow violated the Fourth Amendment, this court's decision in Seidman precludes any finding of error, let alone clear or obvious error. That case really resolves this case.
When they walked in, was he under arrest?
No, Your Honor, no.
Why not? They had a warrant that says to arrest him forthwith, did it not?
They wanted to approach him to see whether he would voluntarily.
I know what they wanted to do, but they had a warrant that said he's under arrest forthwith. And we all know what forthwith means. So when he answered the door, they had that paper duly authorized, right, by authorities. He was under arrest.
No, Your Honor, he was not under arrest until he was placed in custody. They had the authority, the constitutional authority, to place him under arrest. They did not exercise that constitutional authority.
Well, that says, you think at that point when he walked, could he leave?
Yes, that's what well, if he tried to leave, then he would have been arrested, but he couldn't leave. Voluntary.
He was so you're saying they have to put their hands on him for him to be under arrest?
They have to place him under arrest, Your Honor.
I said, no. Do they have to put their hands on him for to be under arrest?
No, Your Honor, that's not the law. But here, if you look,
so it's not the law, but they did have papers that instructed them that says forthwith execute this arrest warrant, correct?
I don't know, Your Honor. I don't recall, but I'm assuming that it does. Yes.
Yes. Yeah.
Now that Maryland.
I'm sorry, I couldn't.
Say, where was that? In Maryland.
That was in Illinois, Your Honor.
Illinois.
Illinois, yes.
State. He was in the United States. He was in Illinois. All right.
Yes, he was in college. He was in a PhD program in Illinois, and
but what judge? Right, they had the warrant in their pocket when they went to see him.
Correct. And this was all litigated as a Fifth Amendment Miranda issue in the district court. Was he in custody?
Right,
but
that's what it was. It was.
And that's not on appeal. That's not. There's no claim that there was error in that determination on appeal. The only claim is that the entry into the home violated the Fourth Amendment, and therefore the voluntary interview must be suppressed. But that's contradicted by Seidman, where a government cooperator entered into a home without consent and then engaged in a conversation that he recorded with the defendant. And this court said, we're going to assume that entering to the home was a violation of the Fourth Amendment, but that voluntary conversation was not the tainted fruits of that. And here, there's no way of finding clear or obvious error under Seidman. It's just, it doesn't follow from that. So again, so there's no question of whether he was in custody. It's accepted that he wasn't in custody.
That may be an argument, but it's certainly, you're right, it wasn't raised here, it wasn't raised then. It wasn't raised with the district court.
Yes, I mean, the issue in the district court was all about Miranda, Fifth Amendment custody. That's not what's at issue here.
They went in the kitchen and sat down with him, didn't they?
Yeah, I mean, what happened was they were outside. We put the,
and they didn't search the house or anything. They just sat down and talked to him.
No, and the district court went all into this when he said when he talked about how they didn't even conduct a security sweep or anything. What happened is and this is on the transcript and the reporting, the agents said, "Can we talk to you?" And they indicated, whether, inside or outside, it was, they were indifferent to that. And he said, "Oh, either way." And they said, "Oh, can we go inside?" He said, "Yeah, sure." So they went inside. It really was for the convenience of the defendant there. It wasn't for any investigative purpose because they didn't search the house. There was no Fourth Amendment intrusion inside the house. There was no search or anything. The agents would have been perfectly happy.
Let me ask this question. If they had told him that what the truth was, I told him the situation that they had an arrest warrant for him, could they have talked to him and asked him those 140 some questions without reading his rights?
Well, I think that at that point, there would have been a totally different calculus as to whether he was in custody, Your Honor, and under Miranda. Yeah, under Miranda. So under Miranda.
No, they had told him that we have a warrant for your arrest.
Yeah.
Didn't take hold of him and then things up and said, "I want to talk to you." They would have to read rights, right? Rights would have to read. Right?
I believe that's correct, Your Honor, because it's an objectively reasonable standard known to the defendant. So at that point, he knows he's under arrest, and so he can't leave. So so then you get into the custodial interrogation parameters of Miranda. Yes, if you're in custody, you have to be read your rights and you have to waive them. But he was not. The district court here found he was not in custody. That's not a challenge on appeal. And so instead of focus and trying to evaluate this through a Fifth Amendment Miranda lens, the defendant has decided to take an entirely new Fourth Amendment tack, which is saying that, oh, well, going into the house, even though it was
Right,
entirely voluntary.
I agree that the tack on the Fourth Amendment, you're absolutely right. It's a different question. All right, that's fine.
Mr. Pelletieri, did you try this case?
I did not, Your Honor. This is I'm in the criminal appellate section in Washington, D.C., and we're handling the appeal for the U.S. Attorney's Office in Maryland. This case was tried by the U.S. Attorney himself. I
just wondered, you're the appeals expert. It's obvious you've done a real good study of it.
Thank you, Your Honor. I appreciate it. Thank you, Your Honor. And if there aren't any additional questions, we would ask that the court affirm.
Thank you, Mr. Pelletieri.
Thank you, Your Honor.
Mr. Newton?
Yes, Your Honor. I want to keep coming back to something that's critically important concerning the first issue. Everything has to be analyzed looking at the language of Section 1956 F1 and F2. The language of F1 says the conduct, it means the charge conduct, by a United States citizen, or in the case of a non-United States citizen, the conduct occurs in part in the United States. That's not particularly clear language. Clearly, if you're talking about a United States citizen who does something abroad, it's just that citizen's conduct by a United States citizen, not what a co-conspirator does. The next clause, or in the case of a non-United States citizen, the conduct occurs in part in the United States. That's at least ambiguous about whether it's just the defendant's conduct who's the non-citizen. At the very least, that raises a doubt, in addition to all the other things I've pointed out. This is not a normal conspiracy for two reasons. One, it's a money laundering conspiracy that doesn't require any act, any conduct. Two, it has to be analyzed through the lens.
You ever been involved in a drug conspiracy?
Yes, Your Honor. I've handled many of those cases.
I suspect that you have. And you know that 846 doesn't have any requirement of an overt act either.
That's correct. Nor does RICO.
That's right. So there are a number of conspiracy statutes that don't require overt act.
That's correct, but they would be analyzed the same way.
There's a lot of law. There's a lot of law on that stuff in the law books. You know.
That's correct.
You refer to this as the first issue. Do you refer to the first issue as a jurisdictional issue?
It is a subject matter jurisdictional issue. The government cites Ford and other cases and talks about venue. What the government doesn't cite in their brief, which I cite in the reply brief, is Arbol. The Supreme Court said in Arbol in 2006, in determining whether something is jurisdictional or merits, you look at the language of the statute. This statute explicitly uses the word jurisdiction. This is unquestionably a subject matter jurisdiction statute, just like 1332 would be in a diversity case. The Title VII statute they interpreted in Arbol, they didn't use the word jurisdiction about the number of employees. Here they use the word jurisdiction about the conduct of the non-United States citizen, and the case has to involve a transaction. Again, you've got to analyze it through the language of 1956 F1 and F2. The government hasn't even talked about the fact that F2 says there has to be a transaction. There's no transaction that's an element of money laundering conspiracy. Why? Why is this an issue? Because they wrote the statute in 1986 before conspiracy was even part of Section 1956. There were only substantive offenses in 1986 that required transactions. Look at the legislative history. I cite it in footnote 15 of my reply brief. Congress clearly was envisioning.
There were plenty of conspiracy charges that could be brought. As you know, the 371, you can bring 371 conspiracies if you want.
That requires an overt act. If that would have been charged.
That's right. An overt act's pretty simple. That could be a phone call or across the street, or it could be most anything.
But it's
overt
not
act doesn't have to be a criminal act, my friend.
Overt act. An overt act.
I want to know who the lawyers that you're claiming were ineffective.
There were two lawyers. One was a CJA attorney who initially handled the case and filed one motion to suppress. The second was a retained lawyer who filed other motions to suppress and also tried the case. So there were two lawyers who filed.
You're saying both of them were ineffective
by not raising the only viable constitutional suppression issue there is in this case. which is when the FBI agents approached him, they said, we would like to ask you a couple of questions, a few questions. It will only take a moment. It will be really quick. Those are all their words. And can we come in and ask you these questions? In Randolph, the Supreme Court said you look at societal expectations in determining Fourth Amendment issues. If somebody comes to your door and says, oh, can I borrow your phone real quick? I need to make a phone call. My tire's flat. And they stayed in your house for 68 minutes and talked for 144 questions about your personal life. That would go way beyond the expectation that society understands you're giving them when they come in. That's exactly what happened. They lied to him. They weren't planning on it in a couple of
To
questions.
see who you were, which ones you were claiming were ineffective, and that all tied to that one issue.
It's all tied to that one issue. I'm only saying all the suppression motions that were filed, this was one that should have been filed. If I could go back to the government's arguments about venue very quickly. Venue is not jurisdiction. That's well established. Venue is not jurisdiction. So anything they cite about venue being proper where a co-defendant does an overt act says nothing about 1956 and F1 and jurisdiction.
Before you go, Mr. New, would you respond to Mr. Pelletier's argument that actus reus alone becomes the conduct, even though overt act is not required for conspiracy for money laundering?
So in my brief, I discussed the dictionary definition, the legislative history definition of what conduct means in 1956 F1. Although in some abstract sense, looking at general conspiracy law, sure, maybe forming the conspiratorial agreement could be viewed as an actus reus in a case that doesn't require an overt act. But the problem is, again, we got to go filter everything through 1956 and its text and its legislative history. Congress unquestionably envisioned action, transaction, involvement, not just a mere conspiratorial agreement. And I will repeat and close with this. The statute was written in 1986. There was no money laundering conspiracy. There was no offense that could be committed without an overt act. There had to be some action by a defendant back then for there to be extraterritorial jurisdiction. They did not amend 1956 F1 or 2 when they added the conspiracy clause in 1992, and then when Whitfield in 2005 said you don't have to have an act or a conduct, just the agreement itself. Bottom line is this is a square peg trying to be fit into a round hole. It doesn't work. Congress should have amended it. They didn't. There's at least a lingering doubt, and an appellant should get the benefit of that doubt. This court should remand with instructions to dismiss the indictment for lack of subject matter jurisdiction.
Well, thank you both for your arguments. Mr. Newton, I note that you're court appointed, and on behalf of the Fourth Circuit, I want to thank you so much for that. We really rely on lawyers like yourself to take on these cases and help us in that regard. We appreciate it.
Thank you.
Mr. Peltier, and thank you for your able representation of the United States.
Thank you, Your Honor.
We can't come down and greet you, but know very well that we really appreciate it. And thank you very much, and we wish you well and be safe. Take care.
Thank you.
And with that, I'll ask the deputy clerk to adjourn this session of the court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.